Hello and welcome to the Unit 3 review. This is Mr. Majewski, and Ms. Majewski started Unit 3 off this week with a quick coverage of the First Amendment. It's my turn to pick up with Unit Subtopics 3.5 all the way through Subtopic 3.9 today. I'm really excited to get into these topics. After all, the Bill of Rights and selective incorporation. Not many more topics we cover this year that are as relevant and important to us in our lives today. 3.5 is going to take us through the Second Amendment, the right to bear arms. 3.6 really looks at those amendments that are balancing individual freedom with public order and safety. And so we'll look specifically at the Fourth and the Eighth Amendments there. 3.7, of course, is selective incorporation, which we don't get without the 14th Amendment. 3.8, of course, looks at due process and what we call the rights of the accused, specifically looking at the Fifth and the Sixth Amendments. Finally, 3.9 subtopic looks at due process and the right to privacy. So there's a lot there, of course. As you know, the parentheses correspond to the College Board unit objectives. If you do need more information, look at those specific AP Classroom videos or topic questions for more information. All right, let's get right into it, and let's start with the Second Amendment. Obviously, this is a very high topic amendment, right? It gets a lot of attention, not a lot of words to it. There is the text of it: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that therein lies part of the problem with the Second Amendment, right? It is short and it's very abstract. And so there are questions that immediately arise from this text, right? Of course, this reference to the militia, that meant state militias at the time. Does that still apply today? Does that apply to just the National Guard? A well-regulated militia implies there should be some sort of regulation on this amendment. Does that mean gun control? And of course, does the Second Amendment apply to militias, or does it actually apply to individual gun ownership and protect gun rights in that way as well? So there have been two primary views on how to interpret the Second Amendment, the collective rights interpretation and then individual rights. Now, collective rights historically has been the way that the Second Amendment has traditionally been interpreted in the United States. In fact, this was the prevailing interpretation all the way up until about the 21st century, until about the early 2000s. And what this said was the Second Amendment really was a collective right of the states to maintain their militias and to be able to arm those militias in the event that they needed them to protect against federal interference, federal abuse. What this meant was the states could regulate individual access to arms, that this right really only applied to the state militias, and states were individually able to regulate access to arms. And that was the case throughout most of our history. As we moved into the 21st century, we saw a switch over to the individual rights interpretation, and that has really become more dominant on the court today. And the individual rights interpretation says that each person has an individual right to possess arms for their own personal defense and for the defense of others. So the Second Amendment has increasingly been interpreted and seen as an individual right by SCOTUS and by the federal courts. But, and this is key, the government does maintain some limited regulatory power, even with the individual rights interpretation. What is the deal with this militia? Why was this militia piece included? Well, remember, at the time that the amendment was written, we were just coming out of the American Revolution, right? We were just beginning this new country, and the Constitution had just been signed. And there was a deep-seated fear of a standing army, of a peacetime army being used as a tool of oppression to control the people in a country. There had been a perception that a professional army was really only needed during a time of war. And other than that, then local militia could handle all other problems. And the militia was really just volunteer civilian citizens who were only partly trained. And they brought their own weapons. They didn't really have any organized uniform or anything like that. But of course, the Revolutionary War showed it was really tough to raise an army at the start of a war. So when the Constitution was written, the the framers gave the government, the national government, the ability to have a permanent peacetime standing army for national defense. And it also stated, hey, that the national government is going to have the power to regulate state militias for everything else. So that's why the militia piece was in there. Obviously, this was primarily how the amendment had been interpreted throughout much of our history until the 21st century, when the Second Amendment began to be interpreted more as an individual right. And the real turning point was in 2008. That was when the court issued the famous Heller decision. This was viewed as a major victory for supporters of the Second Amendment and gun rights, and the reason is because the court officially said, hey, the Second Amendment isn't just about militias' rights to guns. There is a pre-existing individual right to keep and bear arms for lawful purposes like self-defense or hunting that isn't at all related to militia activities, and so you're allowed to keep it for your own individual reasons. And it's not just about muskets, right? The handgun is the quintessential self-defense weapon now, the Heller case said. So the court should decide based on what firearms are in common use at the time to determine what weapons ought to be protected. Now, that didn't mean any and all weapons could be protected or were protected by the Second Amendment, right? There are particularly dangerous or unusual weapons that the court ruled the Second Amendment didn't necessarily apply to. And of course, the court did establish that the right to bear arms is not unlimited, that there are numerous regulations that can still apply and be applied to a potential gun owner, either by the federal government or the states. These include licensing, where gun licenses may be required. This would include restricting gun access to certain groups within society who are deemed a high risk. This might even include certain areas or locations, right, like prisons or schools, as areas where they are not permitted. And even the controlled sale of guns, establishing regulations on where and when guns can be sold as well. Is a regulatory power that the courts have said government does have. So again, the Heller decision is a landmark case because, as we know, it says for the first time individual gun ownership is in fact protected by the Second Amendment. Again, the court has ruled that there are certain protections, right, for gun-related activity, but other activities are not protected according to the Second Amendment. So again, there are limits, right? And this points out, obviously, that there are certain rules and requirements, as we've mentioned, that indicate that are not protected by the Second Amendment. So you're not allowed to anonymously own weapons, right? They can be registered, and serial numbers can be applied to them. And that can be a legal requirement. And you're not allowed to carry your weapon necessarily. There's not an unlimited right to carry your weapon in all locations. The state does still have the ability to regulate, for instance, concealed carry or open carry rules and laws. Not all types of weapons are obviously protected, as we've mentioned. Automatic weapons, armor-piercing bullets, good examples of the sorts of things that can be regulated by a state. Places like schools, I mentioned public buildings, areas within a state can be specifically designated where the Second Amendment wouldn't apply. And of course, certain groups, criminally insane, some convicted felons, they may not be protected under the Second Amendment, right, because of that past behavior. So again, there are limits to the Second, even while the court has established, right, that entitlement to an individual ownership as a Second Amendment right. So how does the federal government then use its powers to regulate gun activity when the courts have increasingly ruled that gun ownership isn't an individual right? Well, traditionally the federal government relies on some of its enumerated powers to try to regulate gun activity, and here are three good examples of powers they have previously used. First, the taxing power, right? They will apply taxes, for instance, to the purchase or sale of firearms, and that can be done to try to influence the supply or the demand of certain weapons. They also can apply registration fees and requirements as an additional, I guess you could say, burden to try to influence, right, the amount of weapons that are available. Additionally, they can use their commerce clause and argue that commerce, right, is being interfered with in an effort to try to prohibit perhaps certain persons or particular types of weapons from being accessible. Of course, the Gun-Free School Zones Act that was originally struck down by U.S. v. Lopez was, if you remember, passed again and is still in place under the power of the Commerce Clause. And then the spending power, right? For instance, the federal government may incentivize certain regulations in an effort to try to get states to adopt them. The famous kind of carrot approach, right? Where the federal government, for instance, offered extra additional federal money if states were willing to adopt federal national background checks for potential gun owners. So again, different methods and ways the federal government can still try to influence and regulate gun activity despite the Heller decision. Now, of course, we have two really important required cases you need to know related to the Second Amendment as well. The first is U.S. v. Lopez, and it deals with guns, and so in that way it's regarding the Second Amendment, although as you know it really involves a lot of other topics, most especially the Commerce Clause. So in U.S. Lopez, remember, the court limited the national government's ability to regulate individual and state behavior under the Commerce Clause. Specifically, if you recall, Congress had passed the Gun-Free School Zones Act, which made it illegal to have a gun within 1,000 feet of a school. Of course, Lopez was a student who brought a gun to school, violated the law, was convicted. Remember, what the court ruled in this is that the possession of a gun in a local school zone is not an economic activity that might have a substantial effect on interstate commerce. And the law is a criminal statute that has nothing to do with commerce or any sort of economic activity. And so what it essentially said was the national government didn't have the right to use the Commerce Clause to justify passing this law. The law was unconstitutional. And so, as we know, what it did was, for one of the first times in close to 100 years, it limited the national government's ability to use the Commerce Clause. Up until that point, the courts had generally been very lenient in allowing the federal government to justify behavior under the Commerce Clause. All right. So anyways, U.S. v. Lopez, a pretty significant case, obviously a required case that you need to know. So is McDonald versus Chicago from 2010. This is actually the case that incorporated the Second Amendment to the states, that required the states to follow the Second Amendment as the national government had to after Heller. Of course, in this case, the city of Chicago had regulated access to new firearms. It required a registration process to acquire guns. Citizen of Chicago sued, and ultimately what the court ruled was that gun ownership was an individual right that was extended to the states as well. So states and cities cannot ban handguns outright. They had to be allowed, but they could regulate them under certain circumstances. So again, these are considered victories this is considered a victory for gun rights, as was the Heller case, and that really wraps up our coverage of the Second Amendment. Let's move now to the Fourth Amendment, another really significant part of the Bill of Rights. And let's look at this one. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what's protected under the Fourth Amendment? Of course, if a search by an agent of the government is to follow all of the legal requirements, then the following things need to happen according to the court's interpretation of this Fourth Amendment. So before the search can take place, law enforcement needs a warrant, and that requires showing probable cause to justify that warrant, to justify the search and seizure that's about to take place. So the warrant has to have been filed in good faith. It has to have been based on reliable information. It has to be issued by a neutral judge or magistrate. And it needs to be specific in terms of the place that is being searched and the specific items that are being searched for. After the search, anything outside the warrant terms is illegally obtained. So if any of those rules are not followed, right, any evidence that is obtained is potentially not going to be available to be used against that defendant. This is known as the exclusionary rule, where illegally obtained evidence is not admissible in court, and anything obtained as a result of illegally obtained evidence is also inadmissible under what is known as fruit of the forbidden tree. So again, it's important for government agents, law enforcement agents, to follow these rules and requirements. Otherwise, they risk defendants, criminals, going free. Now, of course, we know there's a number of exceptions to the Fourth Amendment, and we're going to start with the exceptions on the right side of the screen. First off, a person can consent to a search, in which case the Fourth Amendment protections no longer apply. Additionally, if evidence of criminal wrongdoing is in plain view, then the Fourth Amendment protections for that individual do not apply either. Searches incident to arrest. So if you're about to be arrested, the courts have ruled that law enforcement does have the ability to quickly search you. And of course, that is a acceptable search that is not protected by the Fourth Amendment. Exigent circumstances as well. For instance, if there's a unique safety issue or a timeliness issue where a search is really needed without a warrant, then the courts have generally allowed that. An automobile exception, if searches of vehicles, of automobiles, since they're technically out located in public areas, are generally permissible. What the courts have ruled here is that there is no protection when you're in your automobile. There's no Fourth Amendment protection. And finally, hot pursuits. For instance, if an officer is in a pursuit, they may, in that instance, disregard Fourth Amendment protections for the sake of the situation. We should also mention there are some technological exceptions. Obviously, with the advent of technology, searches and seizures are definitely able to be conducted in ways that were not the case previously. And the courts have ruled there are some technological exceptions as well. One of them, of course, involves the Patriot Act, right? Where the government has been allowed to access electronic surveillance, including metadata, without a warrant. Of course, there have been restrictions to that over time. Implied consent as well. There are certain circumstances, for instance, if you are driving in public, right, you get into an accident, for instance, or are unconscious. In those instances, blood tests for sobriety, since obviously that alcohol content is going to wear off, have been permitted. It's known as implied consent. Also, biosurveillance, for instance, material that can be obtained from discarded trash, right, that you might throw away, can be used and obtained without a warrant. You'll notice all of these generally involve situations where individuals are in public settings, and so that usually means the courts are willing to allow more exceptions to the Fourth Amendment. Let's move to the Eighth, and the Eighth, of course, is another really famous amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And of course, if we break that down, right, we realize the courts have decided there's really three different pieces or parts to the Eighth Amendment protections. The first is no excessive bail, right? Bail for those that have been accused of a crime must be reasonable. It must be proportional to the crime, but the court may consider when assigning bail the seriousness of the crime. The more seriousness, obviously, the higher the bail can be. They can look at the evidence in order to determine whether bail should be higher or lower, and they can consider whether the person that is accused is a potential flight risk. In that event, for instance, bail may be higher to try to reduce the likelihood that person will flee. The second category is excessive fines. No excessive fines may be applied. This means, for instance, as punishment. You can't violate people's due process by causing property loss. The courts have ruled here. So again, fines as punishments need to really be adequate and be commensurate with the crime itself. And then finally, probably the most famous and the biggest part of the Eighth Amendment is no cruel and unusual punishment. The punishment needs to be proportional to the crime, is what the courts have ruled. It should not be an especially heinous or cruel punishment. It shouldn't be one that is considered unusual for that typical crime. Of course, this is a vague definition, and so the SCOTUS has needed to interpret this. And that takes us to this issue probably that is centered around the Eighth Amendment more than any other, the death penalty. And we can really see what we mean by how the court can move its interpretation or change its interpretation over time when we look at the death penalty and its relationship with the Eighth Amendment. So in 1972, the Supreme Court actually stepped in the case of Furman versus Georgia and said that death sentences are cruel and unusual if they are done arbitrarily, if they're done capriciously, right? So there should be set rules, there should be processes in place before someone is sentenced to death. And in many places at that time in the United States, that wasn't the case. And so what the court ruled in Furman is that until a more adequate process to determine who should be put to death was put into place, that there would be a moratorium, that they would end the death penalty. And that temporary end to the death penalty actually lasted all the way till 1976. In 1976, the court ordered that the death penalty was not cruel and unusual when there was a separate trial and a sentencing that was separated from the trial itself. And when you took, as long as the judge and the court took severity, the defendant's nature, and I mean severity of the crime, the defendant's nature, and other comparable information or evidence into account, then the death penalty could be assigned, and it was not a cruel and unusual decision. So again, we see kind of a moving court interpretation here. 72 death penalties are put on hold as cruel and unusual. Once some more defined processes and procedures are laid out, it was permitted again. Now, the SCOTUS since then has they've never prohibited the death penalty, of course, since then, but it has been restricted and regulated, and they've restricted and regulated it based on these following categories. The Supreme Court has said, hey, the nature of the crime matters. So when deciding to put someone to death, it needs to be an especially serious crime, and that almost always means murder. The nature of the accused. So the age of the accused, if they're under 18, or their mental capacity, if they're considered, right, to be of a lower mental capacity, then the courts have ruled, hey, those would be reasons why someone might not be able to be put to death. The method of punishment and execution, if the method is deemed cruel or unusual, then the courts have restricted use of the death penalty. Also, remember, the process for putting someone to death has to be non-arbitrary. There needs to be a process that respects that person's due process. That would mean a series of appeals, a series of checks and verifications before that person was put to death. So again, no prohibition, but definitely restrictions and regulations that have narrowed the use of the death penalty to an all-time low. Let's move to our next topic, which we've already referenced, but it's important for us to come back to it, and that's selective incorporation. Now, selective incorporation is when the Supreme Court requires the states to follow all of an amendment or part of an amendment, like the national government is already required to do. So, forces the states, requires the states to really do what the national government is doing in respecting one of those amendments in the Constitution. And this is necessary because you remember the Bill of Rights originally only applied to the national government, right? It was designed to limit the national government. And so as a result, when you come down to the bottom, to the states, they weren't addressed in the Bill of Rights. And the courts ruled, therefore, that the Bill of Rights requirements really only applied to national rules and national laws. It did not apply whatsoever to the states. In fact, each state had their own Bill of Rights. And that meant that state's court interpreted those rights. Each state's court, all 50 of them, interpreted their Bill of Rights independently of each other. The federal government had its own Bill of Rights, and they interpreted that Bill of Rights independent of the states. And there really was only conflict, right, if a Bill of Rights in a state and a Bill of Rights nationally came into conflict in some way. Well, selective incorporation, therefore, couldn't take place until we got the 14th Amendment, because it was the 14th Amendment, when it was passed, that opened the door to the application of amendments to the states. The Fifth only says no person shall be deprived of life, liberty, or property without due process of law. But this additional 14th Amendment, which said, nor shall any state deprive any person of life, liberty, or property without due process of law, that was the key clause, that was the key addition that allowed for incorporation to take place. And it began in the 1920s, 1925 to be exact, with the case of Gitlow versus New York. And in Gitlow, that was the first time that the Supreme Court said, yes, the states also have to follow an amendment. In this case, it was freedom of speech under the First Amendment. And that set a precedent for the incorporation of other amendments and other parts of amendments, which has continued throughout the rest of the 1900s and into the 2000s. Now, most of the Bill of Rights has been incorporated, right? So that means the state governments are required to respect them as well. There are a few which have not. But as you can see, the process of incorporation continues all the way up through 2020. Let us move to the Fifth Amendment next. And as you can see, there's a lot to the Fifth Amendment and the text in it. Now, you'll notice I've bolded kind of the main sections here, right? These are the most relevant portions of this amendment. And the courts have decided that Fifth Amendment protections really include each of the following. So there's 4 categories here. 1, each person is guaranteed what's known as a grand jury guarantee. That means jurors hear evidence. A grand jury, a group of citizens, hears evidence before a person can be accused of a felony, before they can be accused of a crime. A jury of their peers has to hear the evidence and decide whether there's enough there to even issue that indictment. Secondly, the Fifth Amendment protects what's known as due process, right? The famous due process clause. We will find out that means there are 2 different types of due process that are protected, both procedural and substantive, which we will get into in a little bit later. The third Fifth Amendment protection is double jeopardy. And what double jeopardy protects you from is being tried multiple times for the same crime, where the government just puts you on trial over and over and over again until they get a guilty verdict. Now, hey, I should mention this double jeopardy rule only applies if, in fact, there was a verdict. If there is a mistrial, right, where there's no official verdict given, right, then you can be retried again. And then finally, the Fifth Amendment protects against self-incrimination. You're not required to answer self-incriminating questions, and your failure to do so does not indicate guilt, right? You have that right not to respond as well. Sixth Amendment as well has a number of pieces to it, and again, a number of pieces that protect what we call the rights of the accused. Let's break it down bit by bit. First, the Sixth Amendment provides for the right to counsel. Regardless of your economic status, regardless of the crime that you have been charged with, you are entitled to an attorney, to a counsel. And of course, we'll look at the Gideon case here in a bit, which gave us that right and selectively incorporated it to the states. Public and speedy trial is also protected under the Sixth Amendment. You have the right to a speedy trial, right? So it needs to be conducted in as timely a manner as possible, and it needs to be public, right? Public trials tend to be much more consistently enforced because there are those that are able to watch the trial, monitor the trial for inconsistencies. Sixth Amendment also protects against the compulsion of witnesses, right? The accused is allowed to cross-examine witnesses. They're also allowed to present witnesses that will testify to their own defense. And the accused, of course, can be present in the room during the trial. And finally, impartial jury, right? This says that a jury needs to be a fair cross-section of the community, right? It should look like the community looks. And of course, unanimous verdicts are required for most convictions for non-capital convictions. All right. Gideon v. Wainwright is the famous Sixth Amendment case where the Sixth Amendment was incorporated to the states. Of course, you'll remember this case because Florida had put Clarence Gideon on trial, remember, for breaking and entering and petty theft. He wanted an attorney, but he was denied. He couldn't afford one on his own. He was convicted when he had to represent himself. And of course, what does the court rule? That the Sixth Amendment does require the assistance of counsel in criminal cases at the state level, unless the individual says, I don't want an attorney. All right, so again, states were required to set up and expand their public defender systems much more than they had been previously as an additional protection for those that are accused. We're also going to mention Miranda, right, the famous Miranda v. Arizona case, because again, this includes both elements of the Fifth and Sixth Amendment. Of course, in Miranda, remember, it required all law enforcement, including in the states, to read people in custody their right to remain silent and their right to an attorney. These were known as the Miranda rights, right? Police are required to read these at the moment that a person is arrested so that suspects in custody are aware and familiar with the rights that are available to them. Let's move now to the 14th Amendment, and specifically, we're going to look at two separate categories of protections within the 14th Amendment. There are protections that are located under what we call the Due Process Clause, and then separately protections that are located under the Equal Protection Clause of the 14th Amendment. We're going to start with the Due Process Clause, and what we need to remember is the courts have identified two separate categories of due process. They have identified what we refer to as procedural due process. When a person is accused of a crime, when the government is going to take action against that person, the procedures by which that is done, the rules by which the government has to follow, need to be clear and they need to be followed. The government has to follow the same steps, right, before a person is eligible to lose their liberty, whether that's life, whether that's liberty, whether that's property. So, for instance, they have to follow the warrant rules, right? They have to follow those procedures that the courts have put in place under, as a result of their interpretation of the Constitution. The second category of due process that individuals are protected under is substantive due process. And whereas procedural really wants the government to follow rules and steps when enforcing laws, substantive due process worries about people's due process rights being violated from the law itself, that a law is fundamentally discriminatory against a particular group or an individual so much that their due process is being violated by that law. So we have two sort of different categories that the courts have carved out in identifying due process rights that individuals have. Equal protection, when we look at the Equal Protection Clause, remember, is when the government is making laws or taking actions that classify citizens, those classifications can be examined by the courts to make sure they're not violating the 14th Amendment. Remember, the 14th Amendment requires that all laws and rights be applied equally to all individuals, regardless of any sort of circumstances or classifications of them. So remember what is required for a law to survive, to not be struck down when the court evaluates whether the Equal Protection Clause has been violated. Remember, they're going to apply either a rational basis test, they're going to apply an intermediate scrutiny test, or they're going to apply what is known as strict scrutiny to a particular law to determine whether it violates the Equal Protection Clause, right? Rational basis is generally used as the lowest standard, generally for when laws apply to groups based on social welfare or economics. Intermediate scrutiny is often used, for instance, when laws classify according to gender. And then finally, strict scrutiny is the standard that is used by the courts when analyzing laws related, for instance, to race or national origin. So again, the government, in determining whether the Equal Protection Clause of the Constitution has been violated by a particular statute, will apply different standards based on which group is being targeted by that particular law. I should mention that depending on whether you are a liberal or a conservative, that's obviously going to affect your interpretation of the Constitution. And this slide here is a really nice overall summary, an overview of these differences between liberals and conservatives. So a person who interprets the Constitution liberally is really looking to expand the powers of the Constitution, right? And they're going to point to things like the Elastic Clause, the Supremacy Clause. They're going to look at the Executive Clause and judicial review as ways that the government, the national government, really ought to be able to expand or stretch power. They really view federalism in a cooperative way, where the national and the state governments are cooperatively working together oftentimes to try to address issues. They believe a president should generally be more dynamic, should really try to execute laws aggressively in order to really try to use the authority of the national government to solve issues. Generally speaking, they believe Congress should apply a loose constructionist view, that the Constitution is really just a guide and not written coded law, and that the Constitution's powers oftentimes can be expanded. And a liberal oftentimes looks to the courts to perhaps resolve issues or problems that the legislation won't through decisions that may encourage judicial activism, for instance, with civil rights. A conservative interpretation obviously is going to really view the Constitution in a different way. They're going to look more at the idea of expressed powers. They're really going to look at the 10th Amendment and the powers reserved to states there, and they're going to point to those sections as significant pieces of the Constitution. Of course, they're going to view the role of federalism in a more dual way, where the states and the federal governments really have their own roles and responsibilities. They would prefer for presidents generally to be less aggressive in enforcing or pursuing policies. They, generally speaking, would prefer that the Constitution be interpreted more strictly, like a strict constructionist would do. And oftentimes, right, they're more hesitant for judges making more significant decisions. They oftentimes would encourage more judicial restraint, specifically when it comes to using federal power. Okay, I want to remind you the very famous Warren Court from the 1950s and 1960s was really responsible for a significant reinterpretation of the judicial branch and judicial power. It really became what we refer to as the ultimate activist court. If you take a look at the decisions that this court was responsible for, you can see they really went from a role where the court played a passive role in declaring actions and laws unconstitutional to one where they were very active and aggressive in doing so. And so again, look at this laundry list of significant cases we have covered that were all a byproduct of what's considered an activist court, right? The 50s and 60s court of Earl Warren. By the way, remember, since then, the SCOTUS has generally practiced more judicial restraint, especially more recently. A few more things to wrap up here with the right of privacy. We're going to go to a quick reminder about a case we didn't really cover, but it's significant because it sets a precedent for a required case that we did. So there was a case known as the Griswold case, Griswold v. Connecticut. And in this case, the Supreme Court ruled for the first time that something called a zone of privacy existed, that individuals had a certain right to privacy. Now, it didn't exist within any amendment, but by interpreting the wording of multiple amendments, including the 14th, the court ruled they could see how a right to privacy existed. They didn't really define what it included and what it didn't include, but it then opened the door, once it was established, for the very famous Roe case that came afterwards. And this is the required Roe v. Wade 1973 decision, where the court ruled that a woman's decision to have an abortion is protected by the right to privacy, which was interpreted from the 14th Amendment, 9th Amendment, and through other amendments within the Bill of Rights. Of course, if you remember the background of this, there were multiple plaintiffs. There was, most significantly, a pregnant woman who sued the state of Texas, right, because the state had banned and criminalized abortions. Of course, what the court ruled was that the right to make decisions between women and doctors was protected under this newly created right to privacy. They pointed to the Due Process Clause as a place where they could see that right to privacy established. So the court decided in that case that abortion bans are unconstitutional because, as I've mentioned, the 14th Amendment's due process, substantive due process law rules, and the 9th Amendment's right to privacy. Women and families have the right to make decisions about their family with a medical doctor in privacy. They have a right to privacy when it comes to body decisions, but again, the right is not absolute. It has to be balanced against the interests of the state to protect the life of the fetus. And again, this very significant quote in Roe v. Wade, the right of privacy, whether it's found in the 14th Amendment's concept of personal liberty and restrictions upon state actions, as we feel it is, or in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. So this decision is protected and included within this right to privacy. Really quickly, want to remind you about the 9th and the 10th Amendments. These tend to be amendments that limit national power or delegate power to the states. The 9th says that the rights listed in the Constitution are not a complete list, right? And of course, we know that's been one of those rights that has been used to carve out that right to privacy. And then the 10th Amendment says that any powers not given to the national government in the Constitution belong to the states, which obviously is one of the bases for the federal system that we have. All right, that is going to do it for our amendments review. Ms. Majewski will be back for the final civil rights review, which will take us through the rest of Unit 3. Have a great night, everybody.